So we're back, and I'm going to do a couple announcements here real quick, and then I'm going to get into today's content, which is, once again, it's an advanced video, and we're going back into the mortgage blueprinting, and we're going to do an update to the blueprint that I had laid out, a present situation that I'm working on for one of my family members. But just some quick updates. Again, working on the new website. Some things are going to be changing. Just a couple of different designations. Members are going to be those who's supporting paying the $24 a month. Right now we call you premium members, but moving forward in the new website, the members are going to be those who are paying dues, which are going to continue to be at $24 a month, and everyone else would just be registered users. We're just going to get into the right verbiage because I'm doing some structuring in the background and I'm trying to provide more services for all of the beneficiaries, including myself, of thctrust.org. Okay, right again at the beginning, we're a research organization. We don't give legal advice. We don't offer silver bullet remedies. Research only. I think it's important that I say this because there's been two incidents already where in one incident, a United States District Court uh, was reprimanding someone and accused them of getting oddball ideas from thctrust.org. Then recently somebody else sent me an article where someone was trying to do an acquisition on some commercial real estate property, and they're alleging, now that they found themselves in some type of situation or something, that they got the information from Tex Mason. So these are the type of people that I try to avoid. Unfortunately, I can't really dictate who chooses to become a member and who comes across our information. But I want to let all of you guys know that you're completely responsible for whatever it is that you do. I'm not an attorney and I'm not giving legal advice. I'm just sharing the research with you that I'm doing for myself. Other very important announcements is we are not sovereign citizens. I'm not a sovereign citizen. I would prefer, if you are a sovereign citizen, that that you really look into how you are identifying yourself and the principles that you stand behind. We're not a sovereign citizen organization. We don't really, as an organization, take political views and things like that because we don't want to leave any leeway to discredit what we're doing. We want to stick strictly to the information. And that's why I try to be unbiased with a lot of different things. If I talk about they, I'm not talking about the government. It's not that type of party over here. So I just want to be clear with that. Um, Also, okay, that being said, I'll try to just jump into this video so we can get through it as quick as possible. Registration on our website is free. As a registered user, you have access to a lot of resources. But as a member paying dues, you have access to more resources. And pretty much that's most all of the templates that are created. The information that I talk about today, the redemption of the note, there's a lot of templates and things that go along with that. As premium members, you have access to that. Now, that being said, excuse me, I should call you guys dues paying members, or just members, because members will pay dues. And that infrastructure is changing in the updated site. And one of the reasons why I'm doing that, because ultimately I have a goal to establish a credit union for thctrust.org, and I want to have the infrastructure already in place. And of course, those members that pay dues are going to already be kind of set up to be the first participants in that. And let me also explain, for everyone who doesn't know, being a registered user at THC Trust is free. You have access to a lot of this basic information and a few templates. Being a member, where you're paying dues, which are $24 a month, gives you access to the majority of all templates, including the ones we're going to discuss today. Independent and separate of all of that is the master file and the blueprint that deals with nothing but secured party creditor UCC1 filing status correction and titling your estate. That requires a $150 donation to our organization, and then I give you access to that. This is a very important notice that I'm going to tell everyone, especially those who already have access to the blueprint. Do not, share. You can share the access within your immediate circle that you're researching with. Um, More importantly, what else was I going to share about that? It was something else. Oh, yes. If you've made the $150 donation, you have access to the latest templates. It is important that you are accessing the most up-to-date changes, the most up-to-date research that I've put into the blueprint. I've come to realize that some people made the donation 6 months ago, and they're only operating from the version of the blueprint that they received 6 months ago. They're not going in and accessing the updates. So with the original email that I sent you, I told you how to get the updates to the blueprint. If you don't know how to get those and you've made that donation, contact me, or you're not going to be in alignment with what I'm sharing with you, because the updates are based on the latest research. Okay, so that being said, you can get that for your $150 donation. If you logged into the website, you can click right here and facilitate that. Now let me go ahead and click this, because a lot of people are telling me I'm clicking this and nothing's happening. Let's see here if anything happens. Yeah, it's happening, folks. It's moving kind of slow, but yeah. And then you can put in the amount, which is a $150 donation. So it does work. Okay, cool. I'm just making sure, because some people say that it wasn't. Anyways, let's get to the subject matter. I'm going to kind of get through this kind of quickly, touch on some very important points. Now, I want to let you know this is an advanced topic. So a prerequisite is basically, you can go under here, which you don't have to be a member in order to access this menu right here. And this is kind of a prerequisite, because let's click it real quick here. This puts you in the mindset of understanding how we're approaching remedy in regard to mortgages and foreclosures and things like that. In previous videos, I discussed how I'm learning that they're operating under securities and trust law because they're investing your principal interest, which is your promissory note, so that we have to have a better understanding of who the players are, what these people are doing, and what's supposed to be done, so that then we can come in, establish a trust, and play in the trust and the equity game. So that is kind of the prerequisite to moving forward as being a secured party and operating in trust. And it's a prerequisite for really everything, secured party creditor, and even what we're doing. Um, so again, what we're talking about under mortgages and foreclosures are not quick silver bullet remedies. So you have to take your time. Don't prejudice the hard research and work that I've done by thinking that you're going to use one of these templates and just get a home run without knowing what you're doing. Get a coaching session. Take your time, okay? So this is where you really want to start to get an understanding of this. Specifically this, the 1983 Model Standard Indenture. That's given me a lot of information, including information about redemption of the note, which we're about to talk about, redeeming a security. We really haven't looked at too much. I mean, we collectively, us researchers, and it's one that we should look at, because it is in alignment with the position that they are acting as a trustee under trust and equity and securities laws, investing your securities. They're not going to admit to the fraudulent aspects of what they're doing. They will operate under the presumption that their authority comes from their trust management, which comes from delegated United States laws. So let me click on this real quick, this 1983 MSI. We'll take a quick look at it, and then we'll go into what we want to look at in here. As a matter of fact, let's see if it comes up here. Yeah, I think it's coming up. It's just taking a while. Maybe it's coming up. It's not necessarily coming up. That's cool. I have it on my computer, so I'll bring it up here. And by the way, if you can't find that, excuse me, if you go to my website and for whatever reason you click it and you don't get that, where's it at here? Okay, hold on. Let me get this thing working now. 1983. I know I have that file on this computer. No, it doesn't. Where's that bad boy at? Okay, here it is. This is what I was looking for. This is that same file. So if you can't find it and click it, then Google this. Google revised model simplified indenture, right? And then I'm just going to go in here and type redemption so we can get into this like real quick. Section 3, redemption. Now remember, this is coming out of, again, you got to go look at the videos that I did dealing with trust and equity. You got to go through those references that I pointed at earlier to keep up with this. But I got this out of the, this deals with redemption, and it deals with trustees and the redemption of securities that trustees are holding. So this deals with exactly what we're talking about. This MSI model is like a model, it's a model standard indenture, but this kind of talks about how they're operating the blind trust, if you will. So this is kind of like a guideline, but this guide was built off of the Trust Indenture Act of 1939, the Securities Exchange Commission Act of 1934, and different things of the such. So although this is a guide and it doesn't have specific citations of authority, where I was in the process having to, rush to kind of execute a remedy when they're trying to ramp up for foreclosures, instead of looking up all the laws for the redemption of the note, which I did look up many of them, I relied on this to have taken those laws into consideration. I'm just trying to share with you a little bit of how I operate when I'm doing things. So I came here and I read, this kind of skipped to what's important. You can go in here and read these things. But the selection of securities to be redeemed, notice of redemption. So this is what's important. I want everybody to kind of understand how I do my research. And this is what I said, okay, when I thought about the notice of redemption, this is what has to be in the notice of redemption. They're laying it out: the redemption date, the redemption price, the conversion price. And if you didn't know what any of these things were, you just have to look them up. So you want to be as precise as impossible, as precise as possible, because we want these agents, custodians, and intermediaries to perform accordingly. So anyways, these are the things. So you can look at, once again, I pointed you to this document before, but I'm pointing to this document again for information. It even says list the CUSIP number of the securities and state that no representation is made as to the accuracy of the CUSIP number. So see, that's even letting you know this is the normal course of business for redeeming securities. So you can kind of look at that and get some more information so that your redemption notice is taken serious, right? Check this out: the effect of notice of redemption. Um, upon surrender to the paying agent, listen, see that keyword right there, paying agent, right? These are the security. Remember, I spoke about that word before. Who is the paying agent? Well, from my thought process, say if you're doing a discharge of a mortgage or something, the CFO, the finance officer who has access to the Treasury and has access to the fiscal agent for the Treasury, which is the Federal Reserve, he is the paying agent because he has access to all of those different accounts that are necessary to facilitate commerce when there is no gold and silver money, when commerce has to be facilitated based off of laws and obligations of the United States. He is a fiscal officer, public officer appointed for that role. So now that doesn't by default make him the paying agent. I'm demonstrating to you why you should appoint him as the paying agent. I talked about in other videos how you are in default the paying agent because you have an appointed one. So I think the paying agent is kind of like consistent with how they used to say you do a fiduciary appointment for the person that's going to settle the account. That's the paying agent, that's the fiscal agent, is what I would suggest. But anyways, this is the effect of the redemption. So we call for redemption. Now, here's another thing. This says at least 30 days, but not more than 60 days. There's some other laws under Title 26 that deal with redemption of certificates or securities, and they say 15 days, I say. I believe they say 15 days. I have the references for those, and I'm going to put them in a file. I'm going to show you where those references are here so you can actually click on them. But I wanted to say this is important. I want to, please pay attention to this because I'm going to show you something. We're going to go to the redemption of the note that I did. And what note am I talking about? I'm always talking about the promissory note when we're talking about a mortgage matter. I'm talking about the original promissory, and I believe that redemption right is. Have many of us heard about doing a redemption of the note before? I think I'm the first person that I'm aware of to do it to this depth. And let's walk this thing down. I'm keeping you updated, okay? Let a few of us do this and see how it works. Okay, but this is the important thing that I wanted you to pay attention to. After you give them notice, it says, upon surrender to the paying agent, such security shall be paid at the redemption price stated in the notice. You see that? They say it has to be paid at the redemption price stated in the notice. That means is what you state in the notice, because you have to, the maker has to give the notice, plus accrued interest and the redemption date. Failure to give notice or any defect in the notice to any holder shall not affect the validity of the notice to any other holder. So that let me know I got to do the best that I can to do with it. If there's an error in the notice, it's not going to affect the validity of the notice, basically. And when you get into some of the other securities laws, although you may not necessarily see in here, they are pretty specific that they let the trustee or the whole or the intermediary or the paying agent within a certain amount of time let all the shareholders or beneficial holders or interest holders that are affected by that call for redemption, they have to give notice. Did you understand what I said? I'm going to say that again. There's a reason why I'm pointing you to this. There has to be, as you see in here, let's go back to what needs to be in this notice. The redemption date, which is important. Now, coincidentally, I did a call for redemption to PNC Bank National Association for the mortgage that I'm dealing with, and I made the call for redemption date the 15th of March. This is kind of important. I'm going to tell you why. But there's got to be a call for redemption date, CUSIP number. That's why whenever I'm dealing with a mortgage situation, the first thing I'm going to do is the CUSIP search results. Uh, those who have the master file and the blueprint know how to go about getting CUSIP search results. We have an organization that we work with, and they'll do that research for you. It costs $150. You can email me at coaching@thctrust.org, and maybe I can put you in contact with the people that can do that for you. All right, so because they want the CUSIP number in there. Now, let's see, what else was I going to state? All right, that's what we'll say about that. But again, I told you guys many times, that's an important resource. So this is the prerequisite stuff. Now let's go to what we're going to talk about. Again, now this is for premium members to have access to here. You got to make sure you go under the sub menus. When you click this symbol right here, let the page refresh real quick. Oh, and by the way, one more time. Oh, it didn't. It never came up here. But Google 1933 Model Standard Indenture American Bar. If you want to pull that document I was just looking at, you should be able to access it from Google. So now back to what I was saying. We're doing the redemption of the note, but we're under here. This is where we are. Members who pay dues, thank you for your support. So Quicken Mortgage Blueprinting. Now this is very important that if you're dealing with the mortgage situation, everyone's situation is different. So you have to do some blueprinting. We all may not have to do the same things depending on where we are at. Right. We already talked about some of this in this video, which is also a prerequisite for what we're discussing right now. The first thing I did so far is I put an affidavit of beneficial ownership on the promissory note. So why? Because most of us know that the promissory note is what funds the transaction in the very beginning in one form or another. So here's something to know. These terms have a similar relationship when we're talking about the affairs and the business of our estate. Principal. Why? Because when you sign, when you become the maker of that promissory note and you sign that quote, or that, let's just call it a note, what it actually is. When you become the maker of the note, right, and it's handed over to the trustee, he invests it, right? So if he's investing that note, he's investing it for a principal, which is the main party, the real deal person. Or I can't, but I just want you to get an idea. So when you hear the term principal, put it in context. It's the principal for the agent, whatever the agent you're dealing with. So in many regards, when we're talking about beneficial ownership of the original note, you are the principal, and everyone else that's a trustee or other party is acting as an agent for the principal. But the term principal is actually relevant. For an example, attorney foreclosing under a service agreement is foreclosing for a principal, but not necessarily you. Their principal is your servicer, right? And that servicer's principal is you. Just kind of give you an idea of these terms, because sometimes these things come up, right? So, but we're starting with your principal, or with the principal's interest, or the original issuer, right? So now you can also see another relative term, original issue. Not suggesting that you have to be doing a 1099 OID on this, but I'm just trying to show you where we are starting, the where our value is coming from, that we're going to use to set off, offset, or discharge the obligation. Where is our money of accountability, or our account, come from? It comes from our principal. It comes from our original issue. You can even term this in reversionary interest, because it's interest that reverts back to the estate. It's the return of the property. It's a form of a redemption. So we start with that. Now, when you study Federal Reserve book entry, I'll just call it that to keep it simple. You can get on the Federal Reserve's website and look at the redemption of commercial paper, or not just the redemption of commercial paper. The point that I'm getting at is, when you start doing this type of business, you have to be out. The first thing that I want you to know, which you may have picked up if you did the prerequisites and went into the trust and the equity study, is I always start with the asset in the county. See, I've began to realize that the Birth Registration of Act, the Birth Registration Act, Land Titles Registration Act, all these different acts that require the people to register their property. What is actually going on is your property is being entered into an accounting on the county's books. So before you can use a certificate or a debt instrument or a note or a lien or any of that stuff in equity, it has to be attached to a specific asset. This is why you have to have a page and a book number, or opening. This is why you have to open an account in the county first, which is why I say, with anything that we're trying to use the principal interest, or either our security entitlement interest, or uh you know we have to title the ownership of that and ledger it into our private account, which is going to be a trust holding or something like that. So let's look at what that looks like. And actually, I shouldn't. We're going to only look at it quickly. I already talked about this before, but um, no, we're not going to look at that again. Well, we can look at it real quick, but there was a reason why I was bringing that up. Okay, let's look at it real quick. We're going to look at this UCC, because this is a real one that I did. And it kind of goes with just what we were talking about. It starts with a note. That's why I wanted to bring this up, okay? This right here is an example of a promissory note, if you will. Or excuse me, a note. Let's just call it a note. This is one of the notes that they usually don't record. The only reason why you see a book and a page number in here is because I went and we did the recording after the fact with the affidavit of title. See, we were trying to put this asset, remember it's an asset, we were trying to put that asset on the books. Now, another thing I want you to pay attention to, and I need some feedback from you guys that's listening and paying attention to this. Remember, we're dealing with the maker's note, the issuer's note. You have a right to your own property. They make you register your property, and now you have to secure the property because it's your right. Because once you register it, it becomes insecure, because anybody can attach a lien to it. Now, the first thing that I noticed about these promissory notes is right on the face of it. It says 1 year Treasury index. So you can Google that, and now you already see that that's a Treasury security. No way around it. So there might be a bunch of different remedies that can result in depositing this depositing your security interest to the United States of America to be redeemed in lawful money in one form or another. Because in the hands of the right custodian or intermediary, they cannot really reject or refuse to account for treasury securities, right? So these are some key things. I mean, a lot of people probably never even really noticed that, okay? But so we want the page and the book number to put to get an accounting for the asset, and then we need a title on it. So right after that, this is where your affidavit of title or affidavit of beneficial ownership. So now there's a registering of the ownership of the security. And now, anyway, that's kind of separate. I wanted to just say, as y'all already know, let's see, we already did that. And so we did the affidavit of beneficial ownership. We took control over it. Basically what we're doing is merging the legal and the equitable title. And I hope what you understood out that again is that all certificates, which are equity things, and all UCC3s, which is evidence of debts and liens, which are more ways to transfer credits and debits in equity that are attached to assets. So I hope you understand that whether you're redeeming a promissory note or whatever type of private negotiable instrument that you're doing, if you're using that instrument in commerce, there should be an underlying asset attached to it and a record of that, or an accounting of that. Okay, so now once I secured that, right? Now that I secured title to the equity, that's like a check or like a debt instrument. It's basically money on a UCC account. It's not a bank account, but it's the ledgering of money. Let's look at that one more time here so you can better understand what we're talking about here. If I did the UCC right, if I did it wrong, then you won't understand. But usually I do these things right. Uh-oh, that's not what I wanted to be looking at. We wanted to look at the UCC1. And if I did it right, I did do it right. So you have a value on here. And again, so now this UCC1 is a lien against an asset, you know, book number, page number. This is the asset that the lien is registered against for the sum of whatever. This is commercial paper at this point. You understand how that financing statement now has value, but it wouldn't be valuable if it wasn't attached to an asset. So I hope you understand that. Now, so who is the secured party or the account owner? There it is. That's a trust registration statement. Now, there's something else that you can do. Is it on here? Yes. You put the addendum on here. Why? Because I'm creating an assigner. But I don't want to go into that because I don't want to, yeah, we don't want to go into that. But if I was going to assign this 89,000 to another party, such as, say, the CFO, because remember, I just titled it. If I was going to assign this to him, I would do a UCC3. Now, my next move was not assigning him the interest to discharge the debt. I didn't do that yet. I called for redemption of the note. We just looked at the redemption of the note. I found that under the securities laws. And let me show you some other things real quick with that. I got some resources here. And I'm going to make this available so you can click under this video. And these are just some things. So this is, let's click this real quick. So remember I told you we looked at the trust in the model standard indenture, which has some of the federal securities laws. It talks about redemption in there. Here's Title 26 Code subsection 302 that talks about distributions and redemption of stock. So you can look at this, and since we're Title 26, we're talking about the IRS code. So when you read what they say about distributions, you should consider your IRS forms also. And I would particularly tell you, I know a lot of people are stuck into thinking in terms of 1099 OID, and I'm not saying that that has nothing to do, I'm not saying that that doesn't have anything to do with this, but I'm saying if you're getting a distribution, if you're doing a redemption of the note, there's going to be a distribution of that note, and you're going to receive out of that distribution, supposedly, you might direct it to point A to point B, maybe to discharge a debt, but there's 1099 reporting that has to happen there. And the 1099 OID, which may be a part of it, I believe is for the bank to do. You may want to investigate the 1099R that specifically deals with distributions. I will talk more about that later. Um, but let me say this now for those that are wondering. My understanding is that when you're getting a distribution, such as like the redemption of the note, that the payer is going to be the CFO or whoever you appointed the paying agent, as I was speaking to before, right? You appoint them the paying agent, they become the payor, and they're required to do the distribution, and you need to receive a percentage of that distribution. Just keep that in mind for those who's going to do the researching the 1099-R technology. And by the way, I'm also sharing with you, but I'm asking for your feedback. I'm dropping this information. You can watch this video again, research the references, and see what you come out with. But give me your feedback. I'm doing this stuff in real time. So you can read about the redemption of securities here, read some of the federal laws just to make sure that even if you're doing something and you don't know if this specific distribution and redemption of stocks applies to the redemption of your note, just make sure everything you're doing is in alignment as much as possible, because you're going to find that most of these different codes, regulations, and acts are all saying the same thing. They're just codified in different places. So that was one resource. Let's see, did I have, I have, I think, another resource in there. What did we click? We clicked that. Redemption of treasury notes are acceptable for payment of debts. Did you hear that? The redemption of treasury notes are acceptable for payment of debts. And that's why I was showing you when you go down here that right on the face of these notes, check yours out, they say Treasury Index. This is why we know we can tie the CFO in, because he's a fiscal agent, Federal Reserve agent, officer of the Treasury, and all that stuff. So, and yes, this might be, so sometimes I understand people say, well, they might not be talking about that Treasury type of note, or they might be. You understand? It says 1 year Treasury Index. Google that and see what you find. You might be surprised. Okay, so I'm also going to put this in here. This act of February 25th, 1862, that's where it says that these are, you can go through here and read it for yourself, but that's where it's talking about that those notes, treasury notes receivable, are receivable in payment of dues to the United States. So it's basically saying you can redeem these notes, and they can be, you can exchange them to pay debts against the United States. That's exactly what we're doing. The goal of this, if I haven't already said it and you don't understand, is when a servicer or mortgager or someone's trying to take our property and they say you owe this, we're attempting to do a redemption of our principal or our original issue, our reversionary interest, a redemption of the security of our note. And now that's what I was going to mention. When we do this, so means money is supposed to come back. If people didn't get that yet, it goes without saying, but let's just go ahead and do this because I want to be as thorough as possible. We're just going to basically look up what a redemption is. It's kind of common sense, but just in case you don't know, let's look at, not Merriam-Webster, we're going to look up something like either legal or Investopedia. So let's look at redemption law, or not even law. I don't want to get super legal. We're dealing with commerce. So let's do a redemption in commerce, if you will. Let's do a redemption in investing. Jeez, I don't want to go into no. Okay, here we go. Investopedia. There we go. Fixed. So there's a fixed income security. But again, the redemption is the return of the investors. Remember, when you signed the instrument, they received it and they invested it into the federal. Well, they convert. Either way, it was invested it. But once they deposited it, they did the fractionalizing, converted it, and there was a conversion. When you take one security and you put it in a different platform, it has to be converted. So even when you call for the redemption of it, you have to use a CFO or a treasury agent, someone who's like a broker who can do the conversion. Because the disbursement, 1099-R, or the disbursement, there has to be a conversion on it. So there you go, common sense. I just wanted to touch on what a redemption is because we're talking about it. But the other thing I wanted to say is this call for redemption and notice of redemption, it's under securities law. That's why I treated the call for redemption as a separate process, affidavit of ownership on the note. If I was going to use a negotiable instrument to assign interest in the note or to discharge a debt, I would also have to do a UCC3 assignment to assign that instrument or to assign that instrument somewhere to be discharged. However, the call for redemption is just something I was throwing in there, like you want to do as much as you can. It doesn't require a UCC3. That being said, the reason why I'm telling you that is this. Let's click on the document real quick. I did this call for redemption. Oh, first, we'll go back to the paying agent. Now, another thing I'll say is ideally you can put this all in one presentment. You want to call for the redemption. There has to be a date. The date, the notice of the redemption date, as we just seen when we were looking at earlier. And then you can give a document, because what you're instructing them is to redeem it, and out of your principal, they can pay off their claims, and then they can bring the rest back to you, or actually to your trust, because you really want to be doing this through a trust. So let's look at the call for redemption real quick. It is we kind of just basically went through everything that was in it. There we go. So yeah, it's the call for the redemption. Notice I have all of those things: redemption date March 15th, redemption price, conversion rate, and all of these different things that need to be in the notice to the best of my capability. I also put the remaining proceeds from the sale should be sent to, then I put a trust down here. So you can also Google notice of redemption, call for redemptions, and you can look at some templates and see how that's done. Because I'm also into the countersigning now. The countersigning. So anyways, the redemption date was for March 15, 2017. I did this about 3 weeks ago, and I'm going to show you what happened when I did this. And I want you guys to give me some feedback and give me your take on this. So this is what I did. I sent them a notice of redemption. I sent it registered mail. And what I instructed them to do, let's look at this paying agent. This is important. Well, let's just deal with this as two separate things. But there's your notice of redemption, registered mail, restricted delivery. I sent some other forms with this notice of redemption. I sent, for example, some IRS forms. Let's say IRS Form 56. That's a OMB form. Why am I talking about OMB forms? Listen up. This is very important. What I'm learning, OMB forms, many times when they say it takes this long to respond to this form and all of that, these are for gatekeepers, intermediaries, custodians, those administering the blind trust that you are unaware of. OMB forms are kind of behind the scenes, how they're doing different types of business and accounting for it. Consequently, OMB forms create obligations, federal obligations on certain recipients of them if they're intermediaries, custodians, treasury agents, fiscal agents, and things of the such. So that being said, pay attention to OMB forms, especially where they're specifically relevant to what you are doing. So with this call for redemption, which is something that a maker, owner, beneficial owner, or issuer of a security can do, not saying that you're going to find a law that says a beneficial owner can do a call for redemption, but once you owners understand what a beneficial owner is in regard to what we're doing, you will see that, oh, that is the maker and the issuer, right? So we did the call for redemption, and then let's click on this paying agent. Let's do that real quick. So this is important. But I wanted to say, with the call for redemption, we gave them the instructions of how to disperse the funds. Now, with this appointment of paying agent, I would do a Form 56. I would do some IRS W-8s, because all of those OMB forms require fiduciaries and agents to do certain types of reporting. Now remember, we're dealing with the Treasury security. When you're dealing with Treasury securities, fiscal agents, CFOs, court clerks who are also um, bankers, or excuse me, they are fiscal agents, and they are bankers also. Or they're not bankers. What's the term I'm looking for? They are trustees and judges are bankers. So when you're dealing with these places, these federal regulations under the CFR as for reporting to the Treasury, making those reports, depositing funds, those are very serious violations. So this is how you got to box them in and lock them in. But anyways, let's look at this power of appointment real quick. I, John Doe, depose and say that I have the authority, broad general power of attorney to grant, convey, and assign the powers, duties, and authorities assigned herein for the purpose of discharging, selling, and closing the above referenced account, whatever. This appointment under power shall be considered as acknowledged 72 hours or 3 business days. You understand what I'm saying? I combined these things. You have to make this specific to your process. The appointment of paying agent and a letter of instruction. Why? Because when I did the redemption of the security, I didn't have to do any of this because I knew that they can just do that right off of the laws. But then right after that, I sent them a letter of instruction of how to disperse the funds. So all that is talked about in here. I go through the procedural instructions. See, remember, there's already a UCC1 financing statement with me financing my security entitlement, my principal interest. Now I'm calling for redemption and I'm asking him to do a disbursement on it. And now with this, I'm actually giving him the physical instrument with a copy of the UCC3 assignment and an endorsement on the back. Or maybe I don't want to get ahead of that. If you click through all the templates, you'll kind of see that. Let's see if I got. But anyways, I just wanted to show you. This is the procedural instructions in the disbursement order. In those procedural instructions, I put this is what happens. This is how they disperse. I don't know about disbursements, but I've just had to wing some of this. Commercial paper gets posted by a Fedwire or an ACH transaction into electronic paper. So what happens if you bought a promissory note or some other type of paper to your bank that was going to get converted into the electronic form, such as our security entitlement on the promissory note, they will post it to the Treasury via Fedwire, and it will basically be inputting notes into that system, like the amount and all that type of stuff. You can go into the Treasury Financial Manual. If you want more research on this, go into the discharging debt section of thctrust.org and look at the procedural instructions when I was doing that information on a promissory note. You have to give them instructions. So I appointed him as the paying agent, which is a specific duty that gives him obligations because I know he has the credentials to get into those systems. Then I gave him an appointment of a fiduciary. I hit him with a Form 56 with this, which is an OMB form, requires him to report. And I gave him a letter of specific procedural instructions of how to do the transaction. And then I also gave him the discretion in here to modify these procedural instructions if doing so would be in the best interest of the Treasury. So notice here I said pay to the order of them, 51,000, pay to the order of the United States Treasury the rest. Or you may tell them to pay to the order, pay the rest of it. But see, I put in parentheses for settlement and adjustment because the rest of that is what's due to you, and you may do it by a return, or they may give it to you. There's a lot of different ways that this can play out, but we need to stay focused. Our first objective, outside of the money that could be wrapped up into this that we might get back, is to resolve the matter. So that's why we're calling for the redemption of securities and all these things. I'm going to leave this as that for now, but what I wanted to share with you is let me show you what happened, or where I'm at right now, what happened, what I think occurred, and I need you guys' feedback on this. I think that PNC Bank National Association, you can Google this. I'm going to show you something here. They did a redemption of some real estate securities, and I think it's because of the notice of redemption that I sent them. So let's Google PNC Bank REIT Securities Redemption Call. All right, I just put that in there because I'm going to tell you. Let me show you something here. February 3rd, 2017. I want you to pay very close attention to this right here. The same day that PNC announced this information is the same day that we received a letter at our residence saying that the notice of redemption and the call for the redemption on the promissory note that was attached to real estate. It was attached to a real estate investment trust, just like the same type of securities that they are redeeming right here. Notice their redemption date. The redemption date is on March 15th, 2017. The exact same. Let's look at it. Did I show you my paperwork? I got it here. Here it is. This was my notice of redemption for them. My physical one, notice of redemption. I put it to their CFO. This carbon copy was for the CUSIP number that came back when I did the search on the promissory note. But if you know these real estate investments, they're all tied in and meshed in. So I called for redemption. Notice the redemption date is March 15th, right? So that was when the call of redemption came in. I sent them some W-8s and other information, as you see right there. I don't want to put all my personal information on the screen there. And now let me show you what their response was. They actually sent back a letter. I'm not going to pull up the letter, but it's from one of their senior attorneys saying that what we did had no merit. It came right from their headquarters office, and that same day that they released that letter to us, they released this statement that they're redeeming REIT preferred securities. Now, I want to get you guys' take. I think this is directly related, and this shows you the power of what happens when you're being meticulous with your research and you're following the flow of things. You're not going against the grain. You're saying, okay, you guys have invested this, you guys are following all the laws, and y'all are lawful, and then I'm going to redeem this bad boy. Now, I'm going to tell you one more interesting thing about this, and if you don't, you can verify everything I'm saying, because I sent this notice of redemption to them, certified mail. There's the certified mail number. Here's the green card of when they received it. You don't see a date on here, but you can punch that in and you can clearly see when they received it. It's up here in February. See that? Notice that's in February. And then notice they did that call of redemption. Look at the date when this information was released. And I'm going to show you something about this. They released this information February 3rd is when they gave this notice of redemption out. Well, according to the federal laws, they're not supposed to do less than 15 days. Why, if this didn't have anything to do with what I was doing? Well, it says, see, they covered themselves right here. REIT preferred securities is payable on March 15th, 2017 to holders of record. Then it says on March 1st, 2017. They're supposed to give 15 days notice. They didn't give the notice till February 3rd. I'm pretty sure of it. They're alleging that they did. But no, the notice didn't come out till February 3rd. And the reason is because when it finally got, I think what happened is when they finally reviewed the registered or the certified mail that the call for redemption. These are very serious laws. When you do for a call for redemption, these are high level laws that invest that affect shareholders, the treasury. So giving the notice is imperative. The timely notice that can come back and bite somebody. It can be a serious thing. This is why I think they covered themselves, because they are gambling on hoping that I won't take any further action with this. But they just know that for a paper trail purpose, if this ever came back from the regulators and said, well, this person, they have evidence that you received this call for the redemption of the security and you took no action, they can backpedal and backtrack to this. I think that's what's going on. If you have some further information on that, let me know. Because, yes, companies do redeem securities here and there, but I went and did some backward checking. And what they did right here is not the normal course of business. And I want to share one more thing with you before I get out of here. Since I did that, right, there's been two things, this is all part of the overall strategy, right? Let's see here if I can get back to where I was. Since I did that, remember I separated this. I told you moving forward, and I had to separate this because I was doing this in real time. I was researching this, I was blueprinting it, and I was doing it. But moving forward, I would put the call for redemption, even though you have to give them 15 days notice at least, give them about 30-day notice to be in compliance with the Trust Indenture Act, or the model standard indenture for trust that we looked at earlier. But give them that notice and also put the appointment of paying agent and the disbursement of the payment instructions and possibly your IRS forms in the same presentment. Okay? I said a lot of things in this video. I didn't go very in depth on a lot of things, and you should not rush to do this without researching and building a specific blueprint for your own situation. With that notice of paying agent, consider Form 56s. Consider whatever other OMB forms may be necessary to require them to respond and take action. Remember, these forms are for performance. Forms are for performance, okay? So these things are key. I'm trying to think if I left out anything. Yeah, I put some goodies in here. I'm not going to talk about this, but you'll see. This is in here. See what it looks like. Oh, this is something that I created here. And this has already been long enough. So this is part of what I did with the payoff part. Remember, I did a call for the redemption of the securities, and then I did a disbursement. So I kind of did a little bit of an overkill because I called for them to do a redemption of the securities, and then I still tendered them the entire security. Excuse me, the entire security that they redeemed. I assigned it and tendered it to the CFO to discharge his bank's obligation to me, so everybody can be paid out and the remainder can be sent to the estate. This is a transfer form that you will use in some of that endeavor if necessary, but it's beyond the scope of getting into this right now. These templates are available for the premium members at thctrust.org, or excuse me, for the members of thctrust.org. Donate your $24 a month. You can get a coaching session with me. That's a $75 donation. You can go to the top of the website here and click coaching session to find out more information about that. Anyways, I'm going to keep you updated on how this process is going. Oh yeah, one more thing I wanted to mention. So the last thing I did, once again, was the redemption of the note. They sent me the paperwork saying this has no legal consequence, and that exact same day, they, put out the notice that they're redeeming real estate securities. My promissory note was bound up in a REIT, real estate investment security. The only things that didn't match up for my call for redemption and their public call for redemption is the CUSIP numbers. And I'm thinking that even if I had the right CUSIP number or the wrong CUSIP number, or however you put it, they are not going to admit that because that'll just be too much precision with it. The last thing I would tell you too, quite interesting, is I had separated these processes, the call for redemption and the discharge of the debt process. So within 1 week after the call for redemption, I had put them on notice that I was sending the settlement, an instrument for settlement, which was basically an assignment of the note and the securities transfer form and the paying agent instructions with the 1099, giving them clear and precise instructions of how to disperse restricted delivery to be delivered in 2 days. For whatever reason, that package went all over the world and was never delivered to them. And my gut feeling tells me is that of course they knew that it was coming because I gave them notice, but I think they were scared to sign for it. So you see how powerful the push of the button is. Now, we're still right here. You understand? We're only right here. We have all of these things, some of which have done and some are being done. These things are very powerful and explosive, and these are the type of things that we're doing to resolve mortgage matters. So again, I'm working with JAS.management. If you're looking for solutions uh, dealing with your mortgage and things like that, and you're not really a do-it-yourself person, you can email Anthony at jas.management. Be prepared to invest $3,500 to $5,000 in your situation, and get all your questions answered. Ask what you're going to get for your money. Don't pay for nothing just off of my recommendation. Make sure you're getting your value for it. All right, that's all I'm going to say about this. Thank you for watching. Visit the website www.thctrust.com